second question is, I notice when it comes to premises liability cases, it's always difficult to get a hold of the defendants. As for premises liability, it's always like a runaround, as if you are chasing them. It's a matter of sending the letter, calling the businesses up just to even get their insurance information. Now, what would be the best way to deal with those types of cases? Premises liability, unresponsive defendants, and just to get their insurance information, basically.
Good question. In auto accidents, it's different because when you're involved in a collision, by law, you have to exchange your insurance information. By law, in California, it is on the statutes. You must present your insurance information to all the involved parties at the time of a collision. Premises liability is different. They're not under any law to supply you their insurance carrier. They may not even have insurance. They're not required by law to have it. So we serve them at the place of business, their principal place of business, where the accident happened. All you have to serve is a representative of the business. It can be a store clerk. It can be whoever's there during open business hours. It does not necessarily have to be their agent for service of process, which is listed on the California Secretary of State website. First things first, check the agent on the website. First thing you do, you get a business, you search their name on the Secretary of State's website. It's public information. Determine if they have an agent for service of process. You serve their agent. If you cannot locate their agent for service of process, you get the address of where the incident happened from the client, and you serve them directly at the place of business. It's a good question. I'm happy you brought it up. We don't need to go on a wild goose chase. We know where they're doing business. They're there. They're not moving. They're not going to change. Serve them at that location. The process server serves them with a complaint. Good question. It is a good question about the service of a corporate defendant. We're at an issue here. They're not accepting service. They're being non-responsive. I can't find them on the Secretary of State website. What do? We go to their place of business. It doesn't matter who we serve. All we have to serve is a representative of that business. They all represent that entity. If they're doing something in furtherance of that business, they're a business rep, and we serve them. The complaint, yes, is a defense strategy to go cold. They're not under any legal duties to answer until they're actually served legal documents, legal notice of a lawsuit, a summons and a complaint. That's what we need to serve them through a registered process server. We can serve them anyone who has anything to do with the business. We can serve them. It does not have to be the listed agent for service of process, although states require businesses doing business within their jurisdiction to list someone to make it easier, not just on attorneys and the legal process, but on the state bureaucracy. The state wants to know who they have to send their government documents to. Very important, a very testable issue. Agent for service of process.
Makes absolute sense.
Absolutely. This is a civil procedure issue. And look, if we cannot serve them personally, directly through a representative, there's other means of service as well that are not as strong. There's different levels of service. Personal service, directly handing them the documents from someone who's registered with the state. Second type of service, if it's a business entity, their agent listed with the Secretary of State. Third type of level of service is a substituted service, a representative at the business, someone who's behind the cashier, maybe an employee or a manager. Then there's also service by publication that we posted in the newspaper, a local publication for a certain amount of time. You can even post it in the courthouse. There's different types of service. Obviously, we defer to the stronger types of service, direct service, rather than doing service by publication because it's weak. It's weak service. And with weak service, if you get a default judgment, it can be easily set aside. It's weak. It's got no value to it. We need strong service. It's all about notice. In torts and civil procedure and all areas of law, the issue of notice is always important. always look for the issue of notice. In order to have liability, in order to call someone into court, in order to allege someone did a wrong, they must have notice. The other party does not have notice of any of those issues. There's no fault. There's no legal obligations. There's nothing. They didn't have notice. They're innocent. They have to be informed of the rights they're violating and their legal obligations by law. Notice, legal notice is always at issue. These are testable issues that you have to be on the lookout. And practically speaking, as an attorney, whenever we get a fact pattern, a new case, that's where my mind goes. Did they have notice? Can we give them notice? It's all about notice. There's no legal duties unless we provide notice. Again, this is another issue that always comes up in law, no matter what we do. When we analyze any facts, notice, relevance, notice, and relevance. It goes hand in hand with being thorough and accurate.